but I got the good ones for you. Some of the good ones. I got 4. And so I'll start out with the BIA. And, the listeners probably know some of these. Matter of Fernandez. It's the big one that came out of the BIA in the last 2 months. Again, deficient NTAs, if you're getting sick of them, because I come on your show and talk about them so much, God knows what I am. This is probably the 100th deficient NTA case, but it's going to just keep going on because if an NTA that doesn't have the date, time, and location of the first hearing implicates so many parts of the INA. And you're just going to have these circuits in the BIA addressing all these issues. Some of them, they'll overlap one another. They'll have a conflict. I'm sure something is going to go to the Supreme Court. Quite frankly, whether or not an in absentia removal order needs to be reopened when it was begun with a deficient NTA, I believe will probably go to the Supreme Court within the next 2 months. There's now a circuit split on that issue, with the BIA and the 11th Circuit on one, even though the BIA is not a circuit, and the 9th Circuit and the 5th on the other, but the 5th's all over the place, and that's just 4 entities. So, but putting that aside, that's not what Matter of Fernandez is. That is the Matter of Fernandez, the BIA finally coming around to what needs to happen when there's a deficient NTA in the removal proceedings. The BIA got its hands slapped because it addressed this issue with Bermuda's Coda 2 years ago that said it doesn't matter, a notice of hearing fixes it. Niz Chavez says, no, it doesn't. And finally, in Matter of Fernandez, BIA comes back, says, you know what? You gotta dismiss the case.
Yeah.
Immigration judge. Now that's a paraphrasing of it, but in fact, I'll get to in a sec. They don't say you have to dismiss, but they're saying if it is timely raised, and to me, Matter of Fernandez means if the attorney or the non-citizen says, hey, judge, my NTA is deficient, before the removal proceeding ends, before there's a final order. If that happens, it seems like the BIA is saying the immigration judge can't ignore it. And the BIA quite clearly says the non-citizen need not show prejudice. They need not show anything bad happened to them because of the deficient NTA. And that's a big holding, because some circuits had held that you do need to show prejudice, but it's going to be hard to show prejudice. I mean, if they show up to their next hearing, where's the prejudice? You can make arguments. I've been making the arguments, and they're not frivolous, but I think it's hard. BIA says no prejudice showing is required at all if it's timely asserted, and again, timely assertion seems to be before the end of removal proceedings. Now, the 7th Circuit goes farther and says never need to show prejudice if timely asserted, but if it's untimely, then you could still win if you show prejudice. The BIA, in contrast, seems to be saying if it's not timely, you get nothing. And we'll litigate that. We'll see what happens.
Like, are there probably like a million cases that this hits, or how like?
Well, it's only with the Matter of Fernandez, at least. This is only the active cases in immigration court. How many active cases? Let's call it 1.5 million. How many of them were begun with a deficient NTA? I don't know. Pereira was published by the Supreme Court in 2018. So, hopefully they've gotten their act together a bit. I've still seen deficient NTAs after Pereira, don't get me wrong. But, we're talking hundreds of thousands. Now, the BIA says in Fernandez that the immigration judge doesn't have to dismiss. The immigration judge could, as a matter of discretion, give DHS an opportunity to fix the deficient NTA. But as Judge, what's his name? Is Judge Grant in dissent? So it was a split decision from the BIA. Yeah, as Judge Grant says in dissent, that's not possible because there can only ever be one NTA in a case at any given time. So the second DHS must by definition withdraw the first NTA and then issue another one. But the second an NTA is withdrawn, proceedings are terminated. So it's all termination without prejudice. So even if the case is dismissed or terminated, all DHS has to do is turn around and serve a new NTA, a compliant one. But they don't always do that. And who knows? And there's just so many implications in all of this. And so Matter of Fernandez is the board, in large part, finally coming around to, hey, the Supreme Court, based on the statutory text, created a serious issue in Pereira and Niz Chavez. We got to listen, Supreme Court.
It's just like, this is an ongoing issue. It seems like it's never going to end. affects so many people. And it's just like the Justice Department kind of has to get its act together with DHS and draw a line and say, okay, some of these people, okay, you're lucky, would you do it? Just kind of clean house, because it seems like it's eating up a lot of resources. There are probably a lot of people filing lawsuits and BIA appeals, clogging that system over this. Like,
Oh
it
yeah.
just,
Yeah.
our solution is, clear the system with this.
To be honest with you, to me, this is the obvious thing that the board had to say. I think the interesting one is the in absentia motion to reopen, which I think I've even talked on your show a bit about that. There's a split decision. If, like the Ninth Circuit said in Singh, and what the Fifth Circuit kind of said in Rodriguez, but they've now walked it back a bit. If it is the case, based on the statutory text, that an in absentia removal order must be reopened if premised on a deficient NTA. I mean, you're talking about 3 million cases since 1997. I mean, I have no idea and so many of them have been in this country even after the in absentia removal order. They've married a U.S. citizen. I mean, that would give a path to a green card to tens, if not hundreds of thousands of individuals based on the statutory text, because DOJ and then later DHS was not complying with the statute. And that, I mean, I think the Supreme Court will have to step in there. You've already got a circuit split. So it's fascinating stuff. But I think matter of Fernandez was the natural result of Niz Chavez. But we'll see what happens.
Such a mess. It's just like so weird that this system works the way it does. I mean, I deal with USCIS and NBC and all that kind of stuff, but it's like, this is court. This is like big boy stuff. We're getting deported. Like, how could you?
Yeah.
As kids, we all grow up hearing the Miranda rights, saying you have the right to remain silent, this and that, and we all think it's just like a movie thing. It's a constitutional thing that police have to inform people of their rights. And growing up, I was like, well, like, how do lawyers win sometimes? Because like, why doesn't every cop just say it? Isn't part of the thing? Or like when they're doing searches, don't they do proper search procedures, get a warrant? It seems like a given thing. But like police and prosecutors all the time, they make errors. They don't go by the book. They're kind of lazy or they forget stuff. And they mess it up, and it's just like, really, like, you're professional. Come on, like, just do the basics, write the date or something like that. It's like,
I will say, if I was a DHS trial attorney, I'd be pretty frustrated by this, because under the regulations, a DHS trial attorney is pretty much the only DHS officer who does not have the authority to serve an NTA. So you would think that, like, hey, just like trial attorney, you've got a deficient NTA, fix it. Let's just go, right? But they can't do it. I have no idea what the process is, but I'm sure they have to get some sort of officer to issue a new NTA. They have to be the one organizing it, connecting this person with this person, and making sure it's filed. It must be an administrative nightmare for a DHS trial attorney. I have no idea, but I know that they have to get someone's assistance. They can't just do it themselves. So, I mean, that's the reg. That's the reg that they wrote.